Today on Rochelle's Daily Wire Video Edition, we offer an update on the U.S. Supreme Court. As we stand here right now, there are no pure bankruptcy cases on the Supreme Court's docket for the term that began on October 4. Indeed, in the first 2 weeks of the term, the Supreme Court has denied certiorari in 2 cases, raising the important question of whether the doctrine of equitable mootness is something that the federal courts should be employing, or rather, whether the federal courts have mandatory jurisdiction to review orders such as those confirming Chapter 11 plans. Equitable mootness is most typically, but not always, used to dismiss an appeal from an order of confirmation on the notion that the confirmation order was not stayed pending appeal, and it would be improper and unjust to upset the apple cart and the expectations of people and creditors who were not parties to the appeal. There were 2 very good cases on petitions for certiorari to the Supreme Court, one from the Second Circuit and the other from the Third Circuit, but the Supreme Court refused to hear either of those cases. And indeed, perhaps in terms of the Supreme Court's jurisprudence, that was the right thing to do. Why, you ask? Well, because the idea of equitable mootness is currently in flux. The Third Circuit has trimmed back considerably on that doctrine, and indeed, of course, the Third Circuit is the circuit in which it is most frequently employed. Also, very recently, the Eighth Circuit went very close to abolishing the doctrine altogether. I am actually rather pessimistic in the sense that I do not believe if the case comes to the Supreme Court again, the justices are likewise going to decline to examine equitable mootness. There is, however, one case with a recently filed petition for certiorari that is a very good candidate for Supreme Court review. We have a 2-to-2 circuit split where the circuits disagree regarding the constitutionality of the increase in the fees payable to the U.S. trustee system beginning in January of 2018. The underlying question is whether or not those fees violated the uniformity aspect of the bankruptcy clause of the U.S. Constitution, because they were not immediately imposed on Chapter 11 debtors in the 2 states that have bankruptcy administrators rather than U.S. trustees. Finally, I need to note that there is an arbitration case to be argued in the Supreme Court on November 2nd. It's not a bankruptcy case by any means, but it bears attention because anytime the Supreme Court says anything about arbitration, the question is this: will that doctrine be applied rigorously in bankruptcy cases? I could talk for another hour about these cases and others, but all you need to do is to go to my column on the ABI website, because today, that is to say October the 15th, I'm running a story with an analysis of these and other cases regarding bankruptcy before the U.S. Supreme Court. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe.